Again, we're here on City of Barberton with Woodarski. Each party have 15 minutes to present their argument. The appellant may reserve up to 5 minutes. Do you know how long you'd like to reserve, sir?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal, please.
Okay, very good. You'll note then if it's 3 minutes, you'll see 5 for rebuttal, but it'll be 3, and you're looking more at the top clock to see when it gets down to 3 minutes.
Understood. Thank you.
Keep your time as you look at that. The arguments are being recorded, as I mentioned, so please make sure you stay behind the podium, particularly with Judge Sutton. It would be important that she can see you there. If you move behind there, we can't see you and may not be able to hear you, so please stay up at the podium so we can do that. You should not use the name of children, minors, and victims during your arguments. You can refer to them by names like the child or victim, although I don't know in this case, that would be particularly relevant. The judges have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. Louis Grube here on behalf of defendant appellant Renee Woodarski. I'm joined today by my client and Andrea Whitaker and Mike Gableman, two of the trial attorneys from the Summit Defenders. I hope Judge Sutton's okay. May it please the court, Renee Woodarski never should have been arrested, and she should not have been prosecuted for resisting arrest. A police officer's misdemeanor arrest authority is curtailed by statute to situations in which they have found someone committing an offense, and it is further constrained constitutionally to situations in which an officer has developed probable cause to believe that a crime has been committed. Norton police officer Cody Mitchin had not seen Woodarski trespassing. No other witness testified at trial that she had trespassed, and Woodarski did not commit any crime by refusing his repeated request to show physical identification. She was not asked to provide her name, address, or birth date, and she therefore could not have violated Revised Code 2921.29a. Simply put, there was no reasonable basis for her arrest at all, and her resistance to Officer Mitchin was fully lawful. So this court should discharge her. I'd like to jump in on the statute, the identification statute. So Revised Code 2921.29a obviously requires somebody to provide their name, address, their birth date upon request by a police officer who has some, I think the standard is reasonable suspicion. So we're not contesting there was reasonable suspicion in this case. Obviously, Officer Mitchin was called to the scene, dispatch sent him there. There was some reason to be talking to my client. But without that request, without asking her her name, her address, her birth date, there was no obligation for her to offer any identifying information on her own. Further, subsection C of that statute expressly disclaims that there's any arrest authority if somebody refuses to provide any information other than those 3 clear categories of information. There is no doubt from a review of the full enactment that there are certain situations in which some representative of the state can demand physical identification, and there are other situations in which identifying oneself is all that's required. So if this court has any question about what the statute requires, I'd point the court to the full enactment. That is amended substitute Senate Bill number 9. When it was enacted, there were 2 separate categories. So there's no question in this case, my client was not piloting or renting a vessel and entering a designated port. That's Revised Code 1547.80A4. She was not entering an airport, train station, port, or other similar location in an emergency. That's Revised Code 2909.31A. And she did not rent any aircrafts. That's Revised Code 4563.30D4. Those are the only situations that I could find in that whole enactment requiring somebody to actually hand over a physical ID card, something like a driver's license, passport, something like that. On the contrary, the title of the enactment makes it very clear. Its purpose was to require individuals to show identification or, and this is a quote, or provide personal information in specified situations. The specified situation we are in here, which is where a police officer has reasonable suspicion and wants to talk to somebody, that situation, the statute makes it very clear, you only have to provide identifying information, name, birth date, address. She was not asked for that. There's no dispute about that. Trial record is very clear, exceptionally clear in this case. Officer Mitchin explained in great detail. He said, quote, "At that point, I have a right to identify her in the way that I choose and was trained. You can request somebody's social security number, date of birth, name, identification. I always ask for identification. It's most easy. It has their address, their OL number on there, I think that's license number, their name, date of birth, everything's on there. So they can't really lie to you. It's all on there. he was asking for physical ID. There's really no dispute about that in the record. The state did argue in their brief very generally that he asked her to identify herself, but at trial, this point was boiled down in great detail. He was asking for physical ID. He expressly said he was not asking for her to simply just give her name. That's not what he wanted. He wanted her to go in her purse, find her ID, hand it to him. So that's the case. Did she commit an offense by failing to hand over her physical identification? The statute makes it clear, no.
The trial court also, in your talk about that, did the trial court instruct the jury on the offense of failing to provide ID, or just the offense of criminal trespass?
The trial court, my understanding is that the jury was instructed on both offenses. There was a request. The state wanted, obviously, when you're prosecuting somebody, you want to cover your bases. You want as many versions of a guilty verdict as possible. So the state charged her with resisting arrest premised on this failure to identify, and also resisting arrest premised on this trespass. There were instructions on both. I am going to get into the second assignment of error. I mean, assuming the court somehow gets to a ruling that this statute, which very clearly says name, address, birth date, also requires physical identification to be turned over. Under the second assignment of error, we have contested even the giving of an instruction on trespass, because there's simply no basis for the jury to have entered any factual
I
finding.
understand that part. I just want to make sure I understood properly there was instruction on both of the two potential.
Yes, that's my understanding. Exactly. From the jury's perspective, they were told it could be either or. I think there was even a unanimity instruction in this case. It's something that's kind of hard to get sometimes, but I know that the court was trying to give the jurors what they needed in order to return a fair verdict. I just think that, like, on the record, the ruling to give that instruction was baseless. And actually, the Rule 29 motions should have been granted. I mean, on this record, there's a just disconnect. There's a sense, I think, that people are required to identify themselves to police officers. And sure, that's what the law says. They are required to identify themselves. They are not required to hand over an identifying piece of identification. They're not required to turn over their passport, their license. If a police officer asks you your name, give it to them, right? But that's not this case. We just don't have that case. So on trespass, I do want to dive into the details on that because it's a little more nuanced. She was at the Dollar General. She was in the parking lot. We have no indication in this case that she was told she couldn't be in the parking lot. The law is clear on this. Some form of communication of any restrictions on the use of land is required. It's a prerequisite for any sort of trespass to have been committed. That's the McMeechan case out of the 12th district. It's in our brief. There was concession by silence in the briefing. You know, the state didn't say or identify any witness who said that he or she saw Woodarski trespassing. Rather, the state responded to an argument we didn't make, that no trespass instruction was required because there was no trespass charge. I didn't make that argument. Obviously, and this is the one good piece of law from the Schlagenhaupt case that this court issued in the 90s. If there is a reasonable basis for arrest, if there's some argument that there's a reasonable basis for arrest, you can instruct the jury on some offense that might have been committed. You just have to have some facts. The bedrock law here is you can't give the jury an instruction on which they can't actually make a finding based on the trial record. You know, so we don't instruct jurors on random offenses when there's no reason to believe that that offense was committed. And that's this case. We preserved the error with an objection. State didn't make any harmless error arguments, so all this court needs to do is recognize that there's nothing in the record from which the jury could have made a finding that a trespass had been occurring or even probable cause of a trespass, and then move right on to a reversal. It definitely would have impacted the outcome of the trial. This was a heavily contested issue. There was no evidence of trespass, but it was argued to the jury. The fact that I would like to highlight the most, perhaps, and I know there's been some discussion also in the briefing that my client was acting in a way that gave some question of fear in the mind of Officer Minchin, that he had some fear for his personal safety. And I just think this is like the thing sort of sitting in the background. It's It's the concern, right? That maybe if this court issues this ruling that officers aren't going to be able to arrest people when they start acting in a way that gives them concern. In this case, my client was asked for her identification. Had she wanted to give that identification, she would have had to go in her purse. Officer Mitchell later found her identification in her purse, and so when, in this interaction, he's asking her to turn over her physical ID, and then when she doesn't do it, he reaches for her. First of all, she's not subject to arrest at that time. But second of all, the fact that she's then going in her purse in order to try to get herself out of the situation seems totally reasonable to me. She was asked for her ID was in her purse. There's a lot made in the trial record about the fact that suddenly she started reaching for her purse and it gave Officer Mitchell some concern and that he needed to intervene. There's no freestanding right to arrest somebody who is making an officer concerned for their safety if they have not committed a crime. If they have not threatened the officer, which that did not happen in this case, if they have not committed some other crime, the officer can't just arrest in a moment where they're like, I don't know how this feels. They can detain, sure, but that's not what happened here. He threatened her with an arrest. He told her, I'm going to arrest you if you don't turn over your physical ID. She did not turn over the physical ID. He seized her, he kept control of her, he kept her under arrest, he put her in the police car. Simple case. With that, I'm going to reserve the last 4 minutes and 40 seconds of my time. Thank you.
When you're ready.
Thank you. May it please the court, Michelle Banbury, prosecuting attorney on behalf of City of Barberton and City of Norton, State of Ohio. Your Honors, counsel is focusing on the fact that these two charges were read to the jurors, and he's focusing on the fact that the state can't prove those offenses beyond a reasonable doubt. That's not what the state was attempting to do. That's why this defendant wasn't charged with those two offenses, criminal trespass and failure to identify. The standard, which he did mention, is that the officer has a reasonable basis to believe that a crime has been committed. And we have that in both circumstances. At one point in counsel's brief, he says the officer lacked statutory authority to arrest for a purported criminal trespass because he had not observed such a violation personally. Well, I submit that if officers have to observe a criminal offense personally, we wouldn't have very many arrests in this state. If you go back to the appellant's...
Counsel also seems to suggest there was no evidence on the record showing there was potential criminal trespassing. What evidence did the officer have at the time of this incident that there was a criminal trespassing or may have occurred?
That's exactly what I'm going to discuss right now, Your Honor. If you go to the appellant's brief under their statement of facts, he lays it all out for me. It says the Dollar General store was located at 4003 Eastern Road in Norton, was closing at 10 p.m. on the date of the offense, April 28, 2022. That night, Officer Mitchell was dispatched at 10:03. The call notes suggest that a female was refusing to leave the business after store hours. So that's what the officer hears, that's the nature of the call. And she was threatening store employees. So he arrives at 10:09 p.m. Again, referring to counsel's statement of facts in his briefs. Officer Mitchell reflects, I pulled into the parking lot, exited my cruiser, and saw the store clerk in the breezeway. This is at 10:09. The store's closed. And the defendant, Ms. Woodarski, with some items in her hand, yelling at the store clerk. There was, or he says he sees Woodarski standing outside the store with her car parked immediately to her right. The facts will show in a handicap spot. She addressed Officer Mitchell with a simple hi, as he described heightened and excited. Your Honor, right there is a reasonable basis to believe that this suspect is committing the offense of criminal trespass. I'm not asking for this court to find that those facts existed beyond a reasonable doubt. I'm asking for this court to find that the officer had a reasonable basis. Secondly, with respect to failure to show her ID or failure to give her identifying information. We're not asking this court to find that she violated that beyond a reasonable doubt. We're asking for this court to find that the officer had a reasonable basis to believe that she was not going to give her name, her date of birth, and her identifying information. He asks for her ID, yes. Does she give it? No. Does she say, I don't have it, but my name is Renee Woodarski? No. You know what she responds with? You don't need my ID because I've done nothing wrong. That gives him a reasonable basis to believe that she is not going to tell him who she is. His entire argument is that these instructions were given to the jurors and there's not sufficient evidence to find her guilty of these beyond a reasonable doubt. That is his argument. Because we're only required to show a reasonable basis. And I do believe that the Illyria versus, I know I'm going to mispronounce this, I'm not sure how it's pronounced, Slottenhaupt, 1980 Ohio App Lexus 4101 is a controlling case in this matter. And I quoted, Your Honors, in my brief, pertinent law in this case. And this is a case from this 9th District. In order to determine the lawfulness of an arrest, the elements of the underlying offense leading to the arrest need not be proven. The state only needs to show a reasonable basis for the arrest. The fact that a charge was not filed on the underlying offense is not indicative that the officer did not have a reasonable basis to arrest the individual for the offense. In this case, the court ruled that the defendant committed several offenses which gave the officer a reasonable basis to arrest. Regardless of whether or not the defendant was charged with these offenses, the trial court properly instructed the jury on the elements of the uncharged offenses. As I indicated in my brief, counsel for Ms. Woodarski cited a plethora of cases that I don't really think apply in this particular case. I think there is one case that is controlling in this case, and again, that finds that the trial court was proper in instructing the juror on those underlying offenses in order for them to find that there was a reasonable basis to make an arrest and that she resisted with that lawful arrest and therefore is guilty of resisting arrest.
Counsel, is it reasonable basis to make an arrest or probable cause?
The case law is stating it's reasonable basis to make an arrest. I would think those are interchangeable. Probable cause and reasonable basis, but this is what the case law is saying.
Is it your position that it's reasonable basis to make the arrest for not giving the ID just for failing to show the ID, or is it with her statement including that, look, you don't need my ID because I didn't commit a crime or whatever she said on the record?
Yeah, I don't think it's important that she didn't hand over her ID. I think it's important that there was an indication that she wasn't going to tell him who she was. That by not failing to show her ID. She didn't say, I don't have my ID, or I don't know where it's located. Or give me a second, I have to reach into my purse. She said, you don't need my ID, I've done nothing wrong. She didn't say, I don't have my ID, my name is Renee Woodarski and I live at, and here's my date of birth. She was giving an indication that she was not gonna tell him who she was. She didn't have to because she did nothing wrong.
Is reasonable basis interchangeable with reasonable articulable suspicion under Terry?
I think it's a higher standard than
You think which is a higher standard?
reasonable basis.
Okay,
I think that's more akin to probable cause.
thank you.
Thank you.
And you'll have the 437 for review.
Thank you, Your Honor. Judge Hensel, I'm going to jump in on the question you just asked. We are, it's totally beside the point whether there was reasonable suspicion. Probable cause is the standard, it's a two-pronged standard. You need a reasonable basis to arrest, you need probable cause to arrest constitutionally. Reasonable basis is the, I guess, the element of the offense of resisting arrest. But to have a lawful arrest, you still need probable cause. So they're both intertwined. I think counsel for the state is probably right that reasonable basis and probable cause collapse into each other. But we briefed it separately just to point out that like the statute, the authority to arrest statute is not the only restriction in this space. It is a two-pronged approach. I fully disagree with the state. We are not arguing that they needed proof beyond a reasonable doubt of the underlying offenses of trespass and of failing to ID. They needed proof beyond a reasonable doubt of resisting arrest. That's the reasonable basis to arrest standard. We're not misconstruing the standards here. But just to be very exceptionally clear, my client did not need to hand over her ID, and she did nothing wrong. The state is now pivoting to argue that she needed to answer questions she was never asked. I'm not required to begin shouting my name, my address, and my birth date to police officers anytime I think that they might want that information. My client was not asked to identify herself. She was asked to show physical ID. The officer was extremely clear about this. This was pages of transcript testimony about what he was actually asking for. He wanted her ID because he wanted to look at what was on it, so that she couldn't, answer questions how she wanted to. He just wanted to look at her ID, see what Ohio thought about her, find a bunch of information that he had no business knowing. You literally, if he had asked for her license number, a thing he's saying he was trying to seek out, she would not have been required under the statute to even give him that. So sure, your ID has your name, it's got your birth date, it's got your address, but you're just required to tell an officer that on request. There was no request, that's the whole case. Well, I guess it's not the whole case, trespass. Before I get to that, actually, officers do have to observe an offense personally. That is revised code 2935.03A1. That's why trespass was not established here, even the bare inference of trespass, not available here. My client, sure, she was at the Dollar General right around closing. They checked her out. When the officer came up, she was holding items in her hand. If she had trespassed, they would have kicked her out instead of checking her out. If somebody is selling you goods on their premises, you have a license to be there. It is that basic. My client was at the Dollar General, they asked her to leave, there was some interaction verbally and the police were called, sure. But they checked her out, she left, she was then outside, there's no indication anybody told her to leave the parking lot. That's the whole analysis on trespass. Items in hand. State just read it, that's from Officer Mitchin. When he walked up, she was holding items that she had purchased from the store. If there's any further question about that, State's Exhibit 1-B, timestamp 22 hours, 29 minutes, and 10 seconds to 50 seconds. Also, transcript pages 117 to 118 and 120 to 121. There's no indication of trespass. And further, if they were going to try to permit some reasonable basis to arrest for trespass, at bare minimum, in order to establish probable cause for an arrest like that, you need testimony from the dispatcher. That is the, where is it? That is the Mommy v. Weisner case. No constitutional probable cause to arrest without testimony of the dispatch officer. That is the person who took the report. They're the person with personal knowledge of whatever the caller told them. You can't just rely on the dispatch, which is all that Officer Mitchin was focusing on in his testimony. Somebody wrote the word trespass into his computer. That's not enough. That's not enough to establish probable cause. That's not a reasonable basis to arrest. If you wanted to establish those things, the state should have elicited that testimony on the record. And just to be very clear, the city said they, quote, could have chosen to put on any of the clerks or, quote, the 911 tape, but they declined to, quote, muddy the waters. That's their burden. They would have had to do that. That's how the state would have established any reasonable basis to arrest for trespass. Without that, we have a very clear case where my client should be discharged.
Thank you, Counsel. I see your time is up.
Thank you, Your Honor.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. Again, as I noted, won't conference until Judge Sutton's had a chance to review the videotape and everything, so it might be a few days. The clerk of court will mail a copy of the decision to you on the date it's released. The opinion are also posted on the Ohio Supreme Court